Another big red flag is when you have a lot of different assets going through probate under a last will and testament. You don't want that. Hi, Jeff Mersanti, the Plain English Attorney, and welcome to the video. Today we are going to go over 11 red flags for estate planning that indicate you might need a trust rather than just a will. So let's go ahead and just talk a little bit about the difference between a will and a trust. Now, a will says, here's who I want to administer my estate as the executor. Here's where I want my stuff to go. But it's saying, hey, court, here's what I want to have happen. So as my estate goes through the probate court process, here's how it's administered. Now, this completely dispels any idea, anything that you may invest in the thought that, hey, I have a will, my estate avoids probate. No, it doesn't. A will is that order to the court. Here's how it's to be administered through the court process. In a lot of ways, it's kind of like a prenup where it doesn't avoid divorce court. It just says, here's what I intend. Here's what we intend. So the will is, what do you intend? Now, a revocable living trust is different because it has all of your estate plans and wishes, who's administering it, who's getting what, when do they get it, but it keeps everything out of the probate court system because whatever is inside the trust is administered privately. So really, you're kind of looking at this state court process with a will, and the revocable living trust is, yeah, I don't want the government involved in that allocation and distribution and how that's run. It's just going to end up happening under the direction of the trustee that I pick, not being looked at and scrutinized and all of the formalities of a probate court system. So here are 11 red flags that you might see that are going to say, hey, wait a minute, I think I probably need a trust rather than just the will process. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. All right, so the first big red flag, the kids aren't talking, or the kids are fighting, or there's some kind of adversarial relationship among the kids. Now, I'm saying the kids. This could be the beneficiaries. But if it's to the point where you think, all right, if they end up having some kind of meltdown after you pass on, are they going to end up fighting each other and dragging it or trying to drag it to court? Because if it's in probate, suddenly it becomes a lot easier for everything to kind of come to a head and have a lot of friction, and it's easy to just throw a wrench into the whole probate court system works and say, all right, that's it, we're gonna have to have a judge, or in some cases the clerk of courts, adjudicate this, and now we have formal filings and all of this other stuff, and it gets to be expensive and time consuming. So if you think the kids may end up fighting or challenging this, you don't want this estate to be in probate. The court system is really designed to accept challenges freely and readily. And believe me, in a lot of cases, the attorneys are getting paid out of the estate, even if they fail. So this is just an incentive for attorneys to tell kids who or beneficiaries, oh yes, I think you've been wronged here, or there's a possibility we can do this and do that. And it's just going to disrupt all your plans. So if the beneficiaries are going to fight, keeping everything out of the court system is definitely a bonus for your estate and having things go the way you want rather than the way the attorneys want. All right, a second big flag is the beneficiaries are not responsible with money. Now, this is actually a kind of a two-track answer. The first track is, if they're not responsible with money, then you really don't want to put them in charge of something. So you do not want to make them the executor. And I have families struggle with this all the time. Well, my oldest kid is going to be very upset if I don't make them the executor, and if they're not in charge of my estate, they're going to feel so bad, but they barely have 2 pennies to rub together. They spend money like it's nothing, and they don't keep records. And, oh, well, no, look, you can't give the responsibility of administering an estate, whether it's in probate and you're using a will and they're the executor, or it's in a revocable living trust and you're making them the trustee. They shouldn't be in charge. But the other part of it is if they're irresponsible with money, then you may want to put in some controls and safeguards. Perhaps an age limit, or leaving everything in the discretion of the trustee to make sure that they get their needs met, that they get money when they really need it, and not when they say, oh, I really need money because I need to buy the new Mercedes this year. My car just broke down and I need all this money to get a brand new top-of-the-line luxury vehicle. Oh, no. They can use the money more wisely and say, all right, we're going to need to get you a vehicle, but it's not going to be some expensive brand new luxury car. So the trustee is there to kind of cut off a little bit of that irresponsibility. Now, it could be that they're irresponsible because they're younger, even if they're adults and they're in their 20s or maybe even 30s. That's no guarantee that they're responsible. But sometimes one or more of the beneficiaries is just going to be irresponsible regardless of the age. And if you're trying to protect them and you want to put those provisions in a will, there's a really good chance that the court is going to have to supervise that year after year after year after year until the money's all gone or the beneficiary dies. Do you really want to put the person you're naming to help get your estate settled? Do you really want them to end up being the trustee through a, quote, testamentary trust, through a will, and have them have to report to the court year after year after year after year? No, you don't want to do that. So that's a big red flag, and it makes it much more efficient if you're going to use a revocable living trust. Third big red flag, and this is a pretty big one, a lot bigger than most people think. It's if the beneficiary, usually a child, they're, quote, married to a boss. In other words, they just go along with everything they say. Maybe they got a little bit of an abrasive personality. They kind of control them. Same two-track answer. You do not want that person, that child, in charge of the estate, but you also may want some safeguards, because I've seen it way too much. I've been doing this for a long time, and I've seen beneficiaries like that, kids like that. They're married to someone who's got that overarching controlling personality, and then suddenly they get a bunch of wealth. Oh yeah, we're going to buy this and we're going to title it in both our names, and oh, let's put this money into our joint account, and then we're going to do, and then they end up getting divorced. And you just don't want, on the administration end, you do not want them pushing a spouse that's just going to listen to them and do whatever their spouse says. Okay, well, I know it's mom's estate, but if you're telling me to do this, okay, I'll do it. It doesn't sound fair to me, but I'll just follow along with you. No, you don't want that. And at the same time, if they're a beneficiary, you also don't want them to have to be subjected to that spouse. It's much better if it's in a revocable trust so that it can administer this share for them and have the trustee in between, and they can just simply tell their spouse, look, I don't have any control over it. It's in the hands of the trustee. That becomes very efficient. Another potential red flag, and this isn't necessarily always a red flag, but it could be, if it's a second relationship, meaning, okay, they've been married, maybe they're divorced or widowed, or they're widowed, and there are kids from that relationship, and it's like, well, okay, I want to make sure that my kids are taken care of at the end of the line with my estate, but okay, I married this person, I want to also make sure that they're not being completely cut out of everything. It's very common in these relationships for my clients that have come together later in life. Maybe they've got their own sets of kids, they've built up their own assets, and they say, all right, we're going to do our separate plans, but I want to make sure that if my spouse needs help, that the money's there. So their estate is kind of put into a, quote, holding pattern. Maybe the kids get something when their parent passes on right away, maybe not, but there's something substantial, or all of the estate is held up in trust until that spouse passes on. And if they need money, well, there's a trustee that can give them money here or there, and then it goes down to their kids. If you're going to try to do that through a will, then the whole estate ends up in probate, and then whatever isn't going directly to the kids has to be reported to the court year after year after year until that spouse passes on and the money goes down to the kids that it's supposed to. The other potential is if you're just completely leaving everything to the spouse and you're just going to, quote, trust that they're going to do what's right, they could very well end up cutting out your kids. It's a much more protective way to handle it through a revocable living trust. Administratively, this next red flag, it just makes sense. If you have property in different states, oh my gosh, this is kind of like the slam dunk. If you're ever on the line between a will and a trust and you have real estate in different states, oh gosh, yeah, that should be tipping you towards the trust right away. Well, why? Here's how it works in North Carolina, and I'm sure in a lot of other states it's exactly the same way. If you are a resident in a state and you own real estate there, okay, it comes under the jurisdiction of your overall estate. If you have real estate in other states, and maybe even in another state but different counties, maybe there's 3 pieces of real estate in New York but it's in 3 different counties, suddenly you have to have an ancillary probate proceeding to, quote, clear title over to the beneficiary in each of those counties. So now you're not just talking about probate in the state and in that county where you were a resident, but 3 other separate proceedings in another state or different states. Okay, if you have the revocable trust and it owns all 4 of those pieces of real estate regardless of which state they're in, you don't have to have that probate proceeding in that other state. So it's just part of the trust, and therefore it's off the table for the court to even have to look at. So this ends up becoming much more of a slam dunk. Another big red flag, it's when you have complex assets or a business that needs to be run or continued a certain way. Now suddenly you want a little bit more expertise, but you don't need the court having to oversee this. Now, I have clients and they tell me that they've got this very specific collection. Oh my gosh, the kids are not going to know what this is worth. They just don't get it. They don't understand it. And what I don't want to have happen is my $70,000 say coin collection end up being sold at a garage sale for $500. I need someone who knows what they're doing, and so they'll want to put in clauses that, hey, this needs to be valued by an appraiser so that a good price can be put on it and that it can be sold in an appropriate manner and get full value for it. Well, then if you have to do that through the court process, now suddenly you're filing those appraisals and the executor's kind of being held to this huge standard, and it just becomes a big paperwork hassle that doesn't need to be there if it's in the revocable trust. So if it's in the revocable trust, now suddenly your trustee is the person overseeing all of this and they can get whatever experts are needed, but it's not part of that court process. It's the same exact thing if you have a business that needs to be continued or sold appropriately and you want someone who understands the business or someone who at least understands the valuation and the sale of that business, you can write that into the trust, and now we don't have to worry about any kind of court involvement in overseeing that process. The people you trust are the ones handling that particular sale. So it just takes it out of the government's hands when you're making this kind of sale of something that could be extremely valuable, and not get it weighed down with paperwork and extra costs. So that is also a big one. I have a client, they have a very specific type of business, and they actually have listed, this person is not the trustee, but they're listed in their trust document. This person understands this business. The trustee is encouraged, or highly encouraged, but not required, which means they really should, talk to this person and prior to any kind of sale of the business, and so that they can get that full value. So having these experts but not having it have to come into the court can be much more efficient and make sure you get full value. Now, here's just another tip. It's a little bit of a bonus on this. Rather than depending on the trustee to have to make some kind of sale, if you have maybe a competitor in your market, or just you're in really different markets but the same exact business, and you would want each other's business if the opportunity ever arose, well, now you may be talking about a buy-sell agreement funded with life insurance so that the sale is already kind of set up. It just needs to be executed. And there's no question at that point. You can write into the buy-sell agreement, here's the price, or here's the way you arrive at the price. There's life insurance involved so that the cash and the liquidity is there to make sure that the estate gets the money, but doesn't have the hassle of trying to run or oversee the business, or even really try to negotiate a sale. It's already negotiated ahead of time. Another big red flag is when you have a lot of different assets potentially going through probate under a last will and testament. You don't want that. Now, this is something where there's a big mistaken belief in the questions that get asked. It's ridiculous, and there are attorneys who push this. Oh, your estate is below this amount. You don't need a trust, or you do need a trust because it's over this amount. They're generally talking about estate taxes, which, okay, that has nothing to do with the actual administration of the estate. And honestly, it's a lazy way for attorneys to look at it. If you have one account that's worth $3 million, okay, and you have one beneficiary, well, maybe at that point we could just simply do a pay on death to the one beneficiary, and you can do a will, and you can lay out the contingencies in there and put, all right, if anything happens to that person, it goes to my estate. Now the will structure it, but if it's like a kid and there's, they're healthy, there's no reason to believe they would pass on before you. All right, that's one account with $3 million, one beneficiary designation. Now compare that to $1 million, which is a third less than that one $3 million account. But that $1 million is spread out over 25 different investment accounts. That's a mess. That's a mess if it has to go through probate, because all 25 accounts have to have some kind of paperwork put together and overseen. And if there's any kind of potential change in the beneficiary designation, look, there's just paperwork that's involved. All of those additional accounts make it so that you don't want to have this go through probate if at all possible. So it makes more sense to set up a revocable living trust, have the trust own those different accounts, and now the entire estate plan is just handled outside of the court process. So the dollar amount doesn't really matter that much. It's about the number of accounts and assets that are going to have to potentially go through probate that becomes the big red flag that says, no, let's go ahead and look at a revocable trust instead. All right, another big red flag. You have underage beneficiaries. Okay, so now most of my clients don't just say, all right, well, we're going to put together some kind of estate plan, and at age 18, they get everything. So yeah, we've got about, $1.3 million of assets, and they just get it at 18 if anything happens to us. Whoa, no way. That's way too young for most of my clients. And most of my clients, 25 is too young. 30, it's iffy, you don't know. 40 tends to be that age where my clients say, look, if you haven't gotten your act together by the time you're 40, you're not going to. So the usual setup is, all right, they get it at age 40 without any questions. Up until age 40, the trustee's in charge of it. They can pay for things or they can distribute it early. They have the full power and authority when we do it through a trust. You're 28 years old. Everything seems to be fine. I don't see a reason to hold this back. Here you go. They can always give it early. They're going to say, well, I don't see any reason to hold this back for 12 more years. Here you go. But like I said, you turn 40 and you haven't gotten your act together. Well, look, it's going to get wasted no matter what. Here you go. So having some kind of age limit makes sense. Now, if you write that into a will, it could very well be the court overseeing it and deciding, are they really that responsible? And all the accounting has to go before the court every single year, if not more often. Every penny has to be looked at and justified and recorded, and here's the paperwork for all of it. Here's the statements. Here's the receipts for everything that we purchased. And it's an ongoing paperwork nightmare, not just the estate settlement piece of it that could take, well, I always say 6 months to a year and a half, but having an estate go 2 or more years, that's not unheard of. But having it go that long and have all that paperwork, you're just extending it until that beneficiary gets everything. And now suddenly there's more accounting every single year. Why would you do that if there's the alternative of having the revocable trust handle it? And so now the trustee has to keep records, but they don't have to do it with the formality of court. And now they can just administer everything for the beneficiary and provide it at the right age or in their discretion. So that's why a revocable trust, when you have underage beneficiaries, ends up being a much more efficient way of handling it. Going right along with that, there is the question, do your beneficiaries need a substantial amount of the assets or support as soon as possible after you pass on? Once assets end up in probate because you're using a last will and testament, there's so much paperwork and information that needs to be gathered and placed before the court that it ends up being a nightmare for the person you've left in charge of the executor if they're simultaneously having to get money to these beneficiaries because they could be out on the street or be in default of loans and all this other stuff. That it's like, whoa, wait a minute. The court's requiring all of this documentation, and if you're not 100,000% sure as you're going through this, and somehow or another you're ending up giving more than you should have at some particular point, now you're talking about having to go before the court and justify it. Whereas if it's a revocable living trust and the debts are taken care of, taxes are already paid, the bulk of that money can be available to the beneficiary pretty quickly without having to worry about these extended filings and deadlines and paperwork that has to get in front of the court before you can work with the assets that are inside the trust. So that's another big red flag, that a trust is probably much more efficient than doing a will. Another big red flag, and this one is a huge one for some of my clients. If there is drug addiction in one of the beneficiaries, or at least one of the main beneficiaries, or even past drug addiction by one of the beneficiaries, you don't want to necessarily give them a whole chunk of money right up front. So having it held in trust by the trustee makes sense. And again, if that's happening in your will, you're setting up a testamentary trust so that the money's being held for this beneficiary that has drug addiction problems, and it's left in the discretion of that trustee. Now suddenly they're going to have to report to the court every single year. Are you complying with these terms? Did you notice anything about the drug addiction in the beneficiary? Do we have any medical reports and all this other stuff? In addition to all of the financial stuff. If it's done through a revocable living trust, you're taking the government out of that process so that it's your trustee who's making these decisions, keeping records still, but not with court formality. And now they can do what's in the best interest of the beneficiary and not give them a ton of money. Now, this happens a lot, and people don't really realize what they're doing. If they set up an estate, they have a child that's gone through drug addiction and they beat it. 5 years clean and sober. Congratulations. That's fantastic. And there's every hope and even every expectation that they will continue to stay sober. However, the grief of the loss of a parent, coupled with a huge dump of money in their laps, can often lead to, well, okay, I'll just have one hit. Just one to get me through the funeral. Oh, I'll have, okay, this is just too much. Let me just do another hit. And then it's, well, it's only once a day. It's not like I was before. And then before you know it, they've completely backslid and they've got the drug problem again because the money got dumped on them. If you want to put safeguards in place, do it through a revocable trust. Trying to put that into a will just means that the court is going to be more involved than it needs to be. And you certainly don't want to just dump all of the money into the lap of a child or a beneficiary who previously was an addict. Because realistically, once you're an addict, you're always an addict. You're just managing to stay sober. The same is actually true if you have a beneficiary that has special needs. And now suddenly it's not just a matter of will they waste the money that you're leaving you. They could end up losing benefits if it's not handled appropriately. So setting up in a last will and testament, here's some guidelines, and it's going to be held in trust for this beneficiary throughout their lifetime. And again, it could mean that you're reporting to a court every single year. You're putting that burden on the person you're listing as the trustee, which is often the executor. They have this burden of administering it over their lifetime, but having to justify every single penny that's spent and have it go through the court to oversee all of this on an ongoing basis, which honestly, it often means that the attorneys are involved in having to handle this stuff and putting together the filings for the court, which is just an added expense, taking away from the money that's there for your special needs beneficiary. Whereas if it's a revocable living trust, you don't have that court involvement. It's not necessary. And now your trustee can manage the money and focus more on the needs of the beneficiary, making sure that payments are made either to the beneficiary or, more appropriately, simply paying bills the right way or buying things for the beneficiary, or even buying things into the trust being held for the beneficiary to keep those assets off the balance sheet of the beneficiary so they don't lose their benefits. It's much, much more efficient to do that through a revocable living trust as opposed to doing it through a will. So those are the 11 big flags. If you know of any more big red flags, please go ahead and put it into the comments below and let's get the discussion going, because there are a lot of reasons why people should be looking more at a revocable living trust as a way to plan their estate for their situation, as opposed to the standard, well, let's just go ahead and do a will, where the real beneficiaries are often the attorneys. So I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.